Hello, my name is Tiana Kavanaugh, and I will be doing my presentation on due process and potential violations of FAPE and LRE. So what is due process? Due process is a hearing to resolve disputes between parents of children with disabilities and school districts regarding FAPE, evaluations, programming, or placement. Now, what is FAPE? FAPE stands for Free and Appropriate Public Education, and that includes special education services that are provided at a public expense and are under public supervision and direction. They must meet state educational agency standards and also include appropriate education for the state involved. And they also must provide individualized education programs. Now, LRE stands for Least Restrictive Environment, and students with disabilities are educated with their peers without disabilities to the maximum extent appropriate. Now, this does not mean that students cannot be placed in a residential placement for special education. They can still be placed in residential placement, even though it is the maximum environment, but it is the least restrictive for them. Now, one of the cases that I analyzed is IR versus LA Unified School District. And this student was identified for special education services. However, the parent moved the student to a private school. The student then returned to a public school and an IEP meeting was held, and the mother consented for the general education placement with a one-on-one special education aide. 2 months later, another IEP meeting was held due to the student not meeting progress goals, and they recommended that the student be moved to a special education classroom. The mother refused to consent, and the students stayed with their previous placement in the general education classroom with a one-on-one aide. The school continued to recommend the special education placement for a year and a half. The mother continued to refuse to consent to that. The mother then initiated a due process hearing claiming FAPE was not provided. The administrative law judge sided with the district, and the mother appealed and lost. Then the mother appealed again, and they sided with IR, the student, due to Los Angeles Unified School District not initiating a due process hearing within an appropriate time period, so within that hour and a half. But it was not based on the fact that they did not provide FAPE, which is why she lost her initial hearings, because she was basing it off of them not providing FAPE. But they did provide FAPE, and they found that actually they didn't follow the correct protocol for a due process hearing, which is having that in an appropriate time. The next case that I analyzed was WA versus Panama Buena Vista Union School District. And a parent claims that their child was not provided FAPE and was discriminated against based on their disability. The school district identified the student for special education services, and it implemented a Tier 2 plan to address the student's behavioral incidences. The behavior continued to get worse during the 2019 and 2020 school year. So another IEP meeting was held by request of a psychoeducational assessment from the mother. They found that the student was ineligible for an IEP or special education services due to that psychoeducational assessment, finding that the student fell in the average range. Then, in October 2019, a Section 504 was implemented for the student. And in December of 2019, the student was found to be eligible for an IEP based on OHI, other health impairment, and ED, emotional disturbance. And they recommended special education placement due to a smaller class size and more teachers, so there would be less behavioral impact on other students. And then the mother refused to consent and requested the school to fund a functional behavioral assessment with an IE, an independent education evaluator. The district filed a due process hearing with OAH, the Office of Administrative Hearings, in June of 2020 due to declining to decide to fund the assessment. The mother then filed with the OAH in September of 2020, claiming that they were denied FAPE and that they were being discriminated against. Then the school district filed with the OAH in October of 2020 in order to implement the 2019 placement of the student being in special education classrooms. The administrative law judge sided with the district on this case due to them showing all records of them trying to implement such as like the tier 2 behavioral plan, and them continuing to try to implement different things for this student, but it overall not working. And the judge cited that the student will be moved into a special education classroom due to their behavioral incidences and the well-being of the other students in the classroom. The next case that I analyzed is JB versus Kyrene Elementary School District. And a school updated an IEP meeting, or an IEP including behavioral support plan, in January of 2013 for a student with a behavioral and learning challenges due to multiple disabilities. In August of 2013, the school physically restrained the student, which is in the behavioral support plan. The parent then stopped sending their child to school due to being uncomfortable with the incidents in September of 2013 of the child being restrained. And an IEP meeting was held, and the parent informed the school that she would be moving their child to a private school. The school offered to pay for the education and transportation of the child to private school until the end of the year, but would expect the child to return in January of 2014. The parent requested an IEE, an individualized educational evaluation, to be funded by the district, and the district declined. This was due to the parent hinting that they would not be sending their child back and refusing to also allow them to assess the student in person. The district then notified the parent that there wouldn't be any other IEP meetings or funding provided. The administrative law judge sided with the district on this due to the parent insisting that their child would not be returning to that school. Now, all of these cases have in common the least restrictive environment and FAPE. The parent did not want the child to be physically restrained in this case, which would be more restrictive. And then in the other case, such as this one, the parent did not want the child to be in a special education classroom, which is the same as this one. So they all include the least restrictive environment, and they also include that the parent is claiming that FAPE was not provided. However, in several of these cases, they found that FAPE was provided, but there were still other things wrong that the school district did. And that is everything. Thank you so much. Have a good day.